The court disagrees that the Commonwealth is trying to sanitize this young man as an Eddie Haskell who has never been in a fight. I'm gonna F you up.
Fuck you up.
I'm gonna beat your ass.
Beat your ass.
KO. Bang bang.
Bang bang. Bang bang.
Bang bang.
Put it into evidence first.
You need to physically put it in evidence first.
I'll F you up.
I said I will F you up.
No, you didn't say I will F you up. What did you actually say?
That I would fuck them up.
I asked you that, Mr. Jackson.
I will fuck you up. I will beat your ass. Pull up, bitch. Did you find that the interview with Michael Proctor was consistent with the relationship that you've had with him your whole life?
Not really, no.
How is he different?
I'd say more professional.
The Queen, Corey Hopkins, has obtained the sidebar transcripts from both trials. She's released a bunch of them, and she reenacted them with the great Emily C. Let's watch.
Mr. Proctor was the one that was sort of leading the conversation.
Yes.
And when it was done, he said, you're free to go.
Correct.
He didn't take any screenshots or videos of your phone or the contents of your phone.
Nope.
Just let you walk out the door.
Correct.
Your Honor, may I publish the photo?
Why don't you come over here for just 1 second?
May I have that, please?
And this is great because we're going to see what led up to each sidebar that will go in the cover.
So, Mr. Jackson, are you telling me now, after this line of questioning, that this photo that I view as cumulative is essential to the bias of this witness because this witness is your third-party culprit or a third-party culprit witness of yours? Is that why you intend to introduce this exhibit?
Emily's playing the role of the judge and the prosecuting attorney in this trial, which is Low Energy Lally, while the beautiful, intelligent Corey Hopkins plays both Alan Jackson and David Yannetti. Let's keep watching.
No, I don't believe that we are forced at this point to put him in a category of third-party culprit. Evidence is still coming in from the Commonwealth. The evidence is still being explored by the defense. This photograph is specifically to establish the bias and lack of investigation or lack of proper investigation by an investigator. This is evidence that the investigator never should have been interviewing this witness in the first place. It should have lasted far longer than 10 minutes. They should have done their due diligence.
Before allowing a picture depicting Michael Proctor and little Colin Albert at a wedding many years ago, the judge is deciding whether or not she should allow it to be admitted as evidence. And she's questioning the sexy Alan Jackson as to why it would be relevant in this situation.
They did nothing. They never looked at the phones. They never looked at the text messages. They never looked at the phone. They never saw an extraction. This was a 10-minute conversation with someone a year and a half after the fact that they left alone for pretty much a year and a half, notwithstanding the fact that he was at the house for the interview at or around the time that John O'Keefe was injured. And the court seems to have an issue with establishing basic bias, and that's part of our defense. This entire investigation has been crippled by bias, personal relationships, favoritism, etc. This is absolutely some of the best evidence we have of that. It's not cumulative of anything. We haven't put photographs in. It's not like this is the 10th photograph, one, and it's certainly not more prejudicial than probative. It's highly probative to the relationship and the interpersonal relationships these witnesses have with this, especially this witness has with the Proctor family.
What is the Commonwealth's position? The Commonwealth's position is the same. It's not evidence of that.
That's our favorite low-energy prosecutor, Alan Lally.
And as far as it bears on the investigation, that does not bear on this witness. He doesn't control what questions are asked or what things are asked of him. Furthermore, as far as anything to do with third-party culprit, there's no evidence of third-party culprit because there is no evidence of a third-party culprit specifically as it relates to this witness.
Third-party culprit refers to the fact that someone other than the defendant actually committed the crime. Here we had little Colin Albert, and he was initially implicated because the private investigator that went to David Yannetti's office named him. We now know little Colin Albert had nothing to do with the murder of John O'Keefe, and by the second trial, because all the evidence pointed to the real killer,
Brian Higgins,
the defense was no longer allowed to raise this. However, this is in the first trial where they don't necessarily have the evidence about Colin, but they're trying to prove it.
Or numerous witnesses who have already come and testified before this jury that he wasn't even there at the same time as Mr. O'Keefe was. I asked you that, Mr. Jackson, because I think that might be a bias to let it in. But on that basis, it is strictly cumulative and it's not coming in. Is there anything else you want to say?
If we develop a third-party culprit defense to our satisfaction, ultimately that we are comfortable with, and ultimately that the court is comfortable with, I think that should come in for that purpose. However, irrespective,
You can renew it.
I appreciate that. I appreciate the court leaving the door open, but I believe strongly that this goes to a Bowdoin defense as well, which is what we are really exploring at this point.
The Bowdoin defense being referred to relates to the fact that if the defense can prove that the police did an inadequate investigation, that would constitute reasonable doubt and Karen Reed could not be guilty.
Lack of investigative interest in this witness. Why? Because he's a kid that he's known his whole life.
I get that. You got all that into evidence, which is why I contend your own photograph is cumulative. But I will leave it open if you tie it in otherwise. And just so you know, it's DD, okay?
Thank you.
May I inquire you?
Yes.
Thank you. Mr. Albert, I want to shift gears for a quick second. On July 27th, you and your attorney appeared at a hearing in a separate proceeding.
That was Alan Jackson right after that contentious sidebar. Notice how calm, cool, and collective he was because, of course, that sidebar was taken outside of the jury hearing him. Very good job by Alan there.
Correct. I want to draw your attention to February 26th, same month, less than a month after the incident. You were at a place called Fenway Johnny's with your buddies, weren't you?
Correct.
Then I have two documents I'd like to mark for identification with the court's permission to show Mr. Lally.
Okay.
So tell me what you're planning on doing, Mr. Jackson. Start with FF.
FF is just an enlargement of EE, which is that single photo.
Okay, so EE, just for the record, appears to be 6 thumbnails with an additional 6 partials.
This is another sidebar, and they're speaking about the pictures of little Colin Albert's right hand, which showed all of his knuckles bruised.
Yesterday, Mr. Lally opened the door to this line of inquiry, presenting a photograph in February that he claims was in February of this particular witness.
Yes, I was just trying to go back and find the date. What was the photo that's in evidence? Like February 11th or something?
That's what the testimony was. Jackson, which we dispute. Given the fact that he opened the door, he specifically asked the witness questions about his face, his hands, his extremities, etc., implying that this witness having been in a fight. He wasn't in a fight. He's got no injuries suggestive of fight. That particular photo is manipulable. That photo was taken by a family member. It was on their phones. It was on their own data.
Where is there evidence that it was manipulated?
I think the fact that it's manipulable is the evidence that needs to be weighed and balanced. I don't have to prove that it was manipulated, but
I can say that there is no evidence of that. But go ahead, I'll hear this.
so what I can prove is that on February 26th, that photo was not manipulable because it doesn't belong to any of the parties. This was taken at an event logo.
The issue being argued by the defense is that Lally introduced a picture that was taken by a family member. Jackson's claiming that it could have been manipulated in some way. The picture Jackson wants to admit is from a bar for which neither of the parties had access to and in theory cannot be manipulated.
Is taken by an event staff member, so they had no access to dates, times, metadata, changing anything, etc. It shows very clearly that this witness appeared significantly injured, white knuckles, indicating a fight, indicating some level of violence, indicating a physical altercation.
What do you say, Mr. Lally? Your Honor, I don't know that there is any evidence that this comes from a source or that it's not able to be manipulated. I also know, I don't know what that is on the EE that's on the side there, as far as whatever labeling is on there is complete and utter hearsay. I don't know what any relevancy any of the other photos have, but as it pertains to this event, it is irrelevant. There is no evidence that the first photograph is manipulated. There is no evidence that the first photograph wasn't taken on February 11th. And if it was, then there is absolutely no relevancy to this.
Mr. Lally did not have to put that evidence in. He chose to open the door to this. He's put the relevance of this right before the court. He doesn't get to have his cake and eat it too, saying there's no injuries and knowing full well that we have a photo that shows significant injuries.
You're telling me it's February 26th. Just so it's clear, EE is something from Facebook, from someone named Caitlin who posted it. That's not a Caitlin in this case, correct?
No.
And it's a bunch of young adults posing and partying, what I'll let you do, because it appears that the injuries to Mr. Albert's knuckles on his right hand in FF are not recent, I will let you put it in Colin Albert 34 means he posted this himself.
I'm assuming he did.
Okay, so the Colin Albert 34 will come off because you don't know. You can show him, I'm not letting EE in.
I would say I'll redact everything on EE. He has already established, I don't need EE. He just established that he was there on the 26th. That's all I need.
Right, so you can show him this and you can put this. I realize it's post February 11th. Miss McDermott, could I have that photograph? What exhibit number is the photo? I think it's either 83 or 84. 83 or 84? It's in the book. Miss McLaughlin's going to get it. Do you know if you can see his right hand in that? I think it's hanging down by his side and you can see it. But there was a separate one where he doesn't have his arm around somebody, and I think that's the right hand. Is that the right hand? I believe it is, yes. Your Honor, for the record, also with those exhibits, as the court had requested, we redacted the dates off those. Yes, oh, thank you. Also, showing right knuckles in 82. In 83, you can see his right hand. Okay, I'm going to give you that. It's giving you quite a bit of leeway, Mr. Jackson. So that has to be redacted if you intend to show it.
I'll just ask my IT person to just show this portion without the...
Yes, I don't think you can separate them.
No, that's impossible.
The Johnnies, all right? I'll give you EE in case you need it because he doesn't remember.
Understood. Thank you.
You need to physically put it in evidence first.
Sir, do you recognize those two documents?
Yes.
May I publish the...
Put it into evidence first.
Move for the admission of just EE.
So you need to get it to the court reporter.
May I, I'm sorry, just FF? May I approach?
Yes.
Do you see that photograph?
Yeah.
Fascinating back and forth between Auntie Bev and the sexy Alan Jackson. However, eventually they were able to get this photo in. We did an entire video as to why little Colin Albert would have never obtained those types of abrasions on all four of his knuckles by punching someone. Obviously, I'm saying this with the benefit of hindsight, knowing that little Colin Albert was not involved at all.
Are you in that photograph?
Yes.
Did you post a video? You threatened that you're going to...
Objection, Your Honor.
The objection sustained. I'll see you at sidebar on this. I'm familiar with this.
All right. So this is one of the videos that people were kind enough to send me. There are two drunken videos with this kid. Is that right? That you sent me?
I don't know if they're drunken or not, but 2 videos of the kid.
Okay.
One is just to define them. One of them is the advantage voice. I'll F you up.
I said I will F you up.
No, you didn't say I will F you up. What did you actually say?
That I would fuck them up.
And the other one is KO, bang bang,
Bang bang!
bang bang.
That I would beat them up.
Did you say you would beat them up, or did you say I will fuck you up?
As sexy and beautiful as Alan Jackson is, old Emily C. let her off the hook because she needs to say the actual words. It wasn't written effed up, it was fucked up. In the law, you cannot alter evidence, even if you think it may offend someone. If it says fucked, you have to say fucked.
I will fuck you up. I will beat your ass. Pull up, bitch. I'm gonna fuck you up.
Especially if you're as beautiful and as sexy as Alan Jackson.
2 separate videos.
Neither one of them depicts fighting, right?
They both threaten fighting significantly.
What do you say, Mr. Lally? They're videos of a high school kid talking about a hockey team. There's no evidence that any fight ever occurred between himself and this group. There's no evidence that was ever actually followed up on. So it doesn't go to bias. It doesn't go to impeachment. It goes strictly to character, which is subject to the motion in limine, which the court allowed as far as reference to any of these witnesses. So I don't see any relevance whatsoever to, it has nothing to do with John O'Keefe. It has nothing to do with anybody that has anything to do with this case. Online social media fodder is what it is.
That's not online social media fodder when he's threatening to, quote, beat your ass, pardon my French, to F you up.
Sexy Alan Jackson. It doesn't say F you up, it says fuck you up.
I will fuck fuck you up.
I'm gonna F you up.
Fuck you up.
I'm gonna beat your ass.
I will beat your ass.
KO means knockout. Bang, bang. These are not innocent musings of a child. These are a grown young man making violent threats towards other individuals, and he testified, I've never been in a fight in my life. The Commonwealth is doing their absolute best to sanitize this person's reputation. It is wrong. It is a fraud on the jury.
What a drama queen our sexy Alan Jackson is. A fraud on the jury? Not sure what he's referring to there.
I disagree with all of that, but
The court disagrees that the Commonwealth is trying to sanitize this young man as an Eddie Haskell who has never been in a fight.
hold on. And committing a fraud upon this jury?
No, I'm not saying that.
You
He just said that.
just did say that.
He did just say it. I'm not saying that he's committing the fraud. I'm saying the witness is committing the fraud on the jury. It's not a true and accurate representation of his...
So explain to me. We are going to need to play the video and have voir dire.
I'm happy to.
All right. I thought it was 2 different videos.
They are.
Which one are you planning to try and introduce?
I was going to do Advantage Boys first, and then Bang Bang second.
I don't remember. I watched these whenever you gave them to me. I just remember 2 drunken videos.
It's been a while. They're probably 10 seconds each. They're not long. Maybe one is 15 seconds.
So what I'd like to do, we will let the jury out. I'd like to see the videos again on the screen as the jury would see them.
Sure.
And then I'll hear we'll see them. We'll have a voir dire of this witness. Then I'll hear your arguments. Then I'm going to go watch them again in my lobby. That's how I'd like to do it.
Yes, Your Honor.
So it will be a long break for the jurors, and you all will get a very short break afterwards, okay?
Understood.
We're going to see a couple of short videos, and then Mr. Jackson will ask you questions, and then Mr. Lally will ask you questions.
Your Advantage Boys, I will beat all your asses. I promise you, I'll fuck you all up. Pull up, bitch. You're a bitch, bro. Fuck you. Yeah, fuck you, pussy. Me cool, boy. You be knocked out. KO. Bang, bang.
It turns out these 2 videos were nothing more than internet fodder between 2 groups of rich white kids playing hockey somewhere in Massachusetts.
That I would beat them up.
Did you say you would beat them up, or did you say, I will fuck you up?
I said I will F you up.
F you up.
No, you didn't say, I will F you up. What did you actually say?
That I would fuck them up.
You also said something about beating somebody's ass, right?
Correct.
What did that mean?
That I would beat them up.
So when you said, I will fuck you up and I will beat your ass,
Beat your ass.
was that a friendly invitation?
No.
I will fuck you up. I will beat your ass. I will fuck you up. I will beat your ass. Were you threatening Advantage Boys guys, whoever they are?
Yeah, kinda.
The sexy and beautiful Alan Jackson, along with Emily C., are continuing their videos depicting what occurred at those sidebars during Trial 1 and Trial 2. We'll link those videos down below. And as those 2 are not stopping, neither are we until the real killer,
Brian Higgins,
is brought to justice.